Hi, I'm Kemp. I'm a lawyer here in Polk County, Florida. The invocations at public meetings in Polk County have gotten a lot of press coverage lately. You may have seen that the Atheists of Florida have sued the City of Lakeland, and the Freedom from Religion Foundation has threatened to sue the Polk County School Board over invocation policies. I'm going to give you an overview of the legality of these prayer practices. First, a quick disclaimer. There are a lot of details I'm going to leave out, so this should be considered as general background information, not legal advice. So let's get started. Here's the chart. Things at the bottom of the chart are things that are clearly not constitutional. You can't do them. For example, during invocations, it is clearly unconstitutional to proselytize. That means you can't attempt to convert someone to your religion during a public meeting invocation. Things at the top of the chart are things that are clearly constitutional, which means they are generally allowed. For example, if a government body elects not to have any prayers at all, obviously that would be okay. In the middle of the chart, things get interesting. The U.S. Supreme Court cases on this topic are not very clear, so I've labeled a middle section of the chart as the gray area. If a situation puts you in the gray area, there is no way to know with much certainty how the case will come out. I'm going to be talking mainly about three factors. One we've already mentioned, proselytizing. Courts don't like it when governments attempt to convert people. Another factor is exclusivity. Courts do like to see prayers being given by a variety of religious leaders from a bunch of different religions. If only one religion is represented, that's a bad thing. Courts also don't like sectarianism. This is when a leader invokes a particular conception of God, such as by praying in Jesus' name or to Allah or refers to the Buddha. So the next step up from proselytizing would be sectarian exclusivity. This is when the speakers only come from one religion, which makes them exclusive, and they reference that religion in the prayers, which makes them sectarian. This is how the Lakeland City Commission and the Polk County School Board have gotten into trouble. In Lakeland, they were accused of only having Christian speakers who prayed Christian prayers. The Polk County School Board was even worse, because there the speakers were board members themselves, not community members. That was a pretty bad idea. Note that Lakeland claims that their prayer leaders were not exclusive, because non-Christian leaders were welcome to lead the prayers too, but that is disputed. Since the Atheists of Florida and the Freedom from Religion Foundation have gotten involved, both the Lakeland City Commission and the Polk County School Board have changed their policies. Instead of being down there in unconstitutional territory, they are in the gray area. Now both groups invite leaders from any religion to lead invocations, so they are non-exclusive, but the prayers are still allowed to be sectarian. So, for example, a Christian leader could pray in Jesus' name, and a Muslim leader could pray to Allah. If they wanted to, they could require that the prayers be non-sectarian too. They would have to instruct the leaders not to pray to any particular god or reference their particular beliefs. This would still put them in the gray area, but they would be more likely to win a lawsuit. So why didn't these bodies move up to that next block? Well, within the gray area, lower courts have come out in different ways. We live in the territory of the 11th Circuit Court of Appeals. This federal appeals court is one level below the Supreme Court and covers Florida, Georgia, and Alabama. The 11th Circuit has drawn the line at the bottom of the gray area in a case they decided involving Cobb County, Georgia. Under that case, the new policies of the school board and the Lakeland City Commission are okay. That's why they didn't move up to the next block. A trial court judge would be bound by that decision and would likely rule that the new policies are acceptable. But that wouldn't be much consolation if there was an appeal, because the law could change in an appeal. In other places in the country, the line is closer to the top of the gray area. In these circuits, the prayers must also be non-sectarian, in addition to being non-exclusive. The policies of the Polk County School Board and the Lakeland City Commission would not be constitutional if subjected to one of those tests. That's why there's a gray area. The 11th Circuit could change its decision and move its line up, or other circuits could move their line down, or the Supreme Court could step in and announce a new standard for the whole country. We just don't know what's going to happen. Until we know for sure, anything in the gray area has the potential to result in an expensive lawsuit. The closer to the top of the gray area, the easier it is to defend the lawsuit. The closer to the bottom, the harder. Just a quick note, sometimes people tend to make a big to-do about the fact that these prayers technically happen before the meeting officially begins. I don't think that has anything to do with it. I just don't see a court allowing an unconstitutional prayer policy to remain in place just because the gavel falls after the prayer instead of before it. There's one more block on my chart. If the Lakeland City Commission or the school board wants to solemnize their meetings and avoid a lawsuit, a moment of silence makes a lot of sense. If I represented either body, that's what I would advise them would be the safest course of action. The further down from there that they go, the more the legal risk goes up. So that's my take. If you have a reaction, positive or negative, I'd love to hear from you. So why not leave a comment? Thanks.